Hey everyone, welcome. It is 2026, and if you're a professional who works with AI, you already know that the ground completely shifted from under us last year. I mean, the old rules for tech liability, they're gone, and they've been replaced by a new standard that's, well, a lot more demanding. So today, we're going to break down exactly what changed, why it changed, and what it really means for anyone who depends on an algorithm to get their job done. Let's dig into how we got here. All right, so here's the plan. We'll start with the old rule, back when AI was seen as just a simple tool. Then we'll get into the whole black box problem that basically made that rule useless. We're going to pinpoint the exact moment everything changed with the Vance versus Nexus precedent, and then unpack its single biggest consequence, flipping the burden of proof. And finally, we'll walk through what this new world of negligence actually looks like in practice. You know, for decades, the law had a really simple way of looking at technology. It was just an instrument, right? If you used a hammer and you missed the nail, you couldn't turn around and sue the company that made the hammer. The responsibility was 100% on you, the user. And for a long, long time, AI fit pretty neatly into that same category. And this comparison right here really shows you why that old logic just fell apart. The instrumentality rule, it worked great when the tool was simple. But modern AI, it's not a hammer. It's a complex and often totally opaque service. If you can't even see how it works, how in the world can you be held 100% responsible for what it does? It's this fundamental change that really forced the entire legal world to catch up. So, this brings us right to the heart of the issue, the thing that totally shattered the old legal framework, the rise of the black box AI. We're talking about systems that make these incredibly sophisticated decisions, but they do it in ways that are often impossible for even their own creators to fully explain. And this is what the courts are now calling an informational abyss. Think about it. When an AI denies someone a loan or flags a medical scan or spits out some research, and you literally can't ask it why, you've got a huge accountability problem. The user is just left powerless, unable to challenge or even begin to understand a decision that could totally change their life. And right here, this is the legal nightmare in a nutshell. You can prove the inputs, your perfect credit history, let's say, and you can definitely prove the damaging output, a loan denial, but the logic inside that box, that giant question mark, is a complete and total mystery. Before 2025, the burden was on the victim to somehow explain what was happening behind that question mark. It was an impossible task. So the consequences of all this opacity, they're serious. It creates what the courts now call algorithmic vulnerability, where the user just has no real power. It lets hidden biases in the training data run wild and create all sorts of discriminatory outcomes. And, maybe most importantly, it creates these massive accountability gaps, where a company could just shrug and say, hey, the algorithm did it, and nobody could ever prove otherwise. Well, that all changed last year with the landmark Supreme Court case that became the turning point for all AI liability, Vance versus Nexus Systems. This is the case that every single legal and tech professional is now, let's just say, intimately familiar with. The ruling in 2025 wasn't just a small change, it was a legal earthquake. The court didn't just tweak the old rules, it threw them out and created a brand new one, the duty of algorithmic vigilance. Basically, it recognized that if a company is going to deploy a powerful, opaque system, it can't just wash its hands of the consequences anymore. And this right here, this is the single most important line from that entire ruling. Really let it sink in. You are now presumed negligent. I mean, this just flips centuries of legal tradition on its head. It says that if your black box AI causes harm, the law is just going to assume it's your fault. The only way out is to prove you exercised what the court called meaningful human oversight. And that leads us to the most dramatic, the most immediate outcome of the Vance decision, the complete inversion of the burden of proof. The legal responsibility has been totally turned upside down. Just think about what this means in the real world. Before this ruling, if an AI hurt you, you had the impossible job of proving what went wrong inside a system you couldn't even see. Now, the company that built and deployed that AI has to open up its records and prove not only that its system worked flawlessly, but also that it was properly supervised. Yeah, the scales have definitely tipped. So what exactly is this meaningful human oversight that can save a company from liability? Well, the court was crystal clear on this. It is not just having a person in the room. It's about active, informed supervision. You can't just rubber stamp what the AI tells you. You have to be able to show that a human understood the recommendation, that they were capable of critically evaluating it, and that they have the real authority to say no.
Okay, so theory is one thing. How does this new standard actually play out in the real world? Let's walk through 3 hypotheticals, but I think you'll agree, very realistic, scenarios of professional negligence under these new post-Vance rules.
So we're going to explore a case in medicine, one in finance, and one in my own backyard, law. And in each one, you'll see how the failure isn't about using the AI. It's about failing to properly supervise it.
First up, the medical field. An AI helps a radiologist by screening scans. It flags one as clear. But hospital protocol and now the new legal standard requires the human radiologist to do a final review. In this scenario, the doctor's busy, they trust the machine, and they just sign off. That is a textbook failure of meaningful human oversight. The negligence here isn't the AI's mistake. It's the doctor's failure to do their job and supervise.
Next, let's look at finance. A bank's AI denies a loan application. Turns out the system was trained on biased data, which led to a discriminatory outcome. The loan officer is supposed to audit the AI's reasoning for any denial. But they're under pressure, they've got high caseloads, and they just click accept to move on. Once again, the company can't blame the algorithm. The failure was the loan officer's passive acceptance, not doing the required audit.
And finally, a situation that is keeping a lot of lawyers up at night. A junior associate uses a generative AI for legal research. The AI hallucinates, which is a nice way of saying it just completely makes up, a court case that perfectly supports their argument. The lawyer is so excited, they don't do the most basic check, verifying that the citation even exists. They put it in a filing and send it to the court. Under the Vance precedent, this isn't just an embarrassing mistake anymore. It's clear-cut professional malpractice. So, that's the new world we're all navigating. The burden has officially shifted, and the demand for active, meaningful human oversight is the new law of the land. Which, of course, leads us to the big question we're all wrestling with now. As AI gets even more complex and even more integrated into our lives, is just having a human in the loop, is it really enough to make sure these systems are used safely and fairly? That is the challenge that every single one of us is facing right now. Thanks for joining this.
Let's get straight to it. As a chief risk officer, I'm not here to talk theory. I'm here to give you a direct, actionable briefing on how to transform the risks of AI into your own professional sovereignty, and we're starting right now.
So let's kick this off with a question that should be on every professional's mind. Your signature, your professional stamp of approval is worth a fortune, but is the AI you're using even aware of that massive responsibility? In this new algorithmic age, you absolutely must have an answer to this. Your career and your reputation depend on it. First things first, we have to understand the new landscape of liability you're operating in. This is not some far-off future problem. This is the reality of your practice today. At the heart of the issue is this concept: algorithmic vulnerability. Think about it. It's the perfect term for the risk created by these opaque AI black boxes. You can't see how they're making decisions, and that obscurity is exactly what exposes you, the professional, to completely unpredictable and catastrophic failures. And make no mistake, the legal system is already catching up. Courts are moving towards a standard of strict liability for AI platforms. AI hallucinations aren't being seen as quirky little bugs anymore. No, they're being treated as fundamental defects in a service, and that puts you right on the front line when that service inevitably fails. So here's our strategic plan to counter this threat. We're calling it the Sovereignty Protocol. We'll go through this 6-part briefing, but I want you to really focus on the 3 core defensive layers we're building: the audit trail, the contractual shield, and the human firewall. Okay, let's dive right into our first defensive layer, the audit trail. This is all about one thing: creating an undeniable, rock-solid trail of evidence. Because believe me, when you're in court, the best defense is always irrefutable proof of your process. Now, what you're seeing here isn't just a list of suggestions. To have any chance of satisfying a court in 2026, your audit trail must meticulously log these 8 metadata points for every single AI interaction. This is completely non-negotiable. You have to think of this as your system's black box. It's flight data recorder. It's the only evidence that will ever prove you followed a rigorous professional process. Now, let's move on to our second layer of defense, the contractual shield. This is where we get smart. This is where we take your AI provider's terms of service and turn them from a liability into a strategic asset for you. Your firm must, and I mean must, negotiate a technical guarantee clause that looks exactly like this. The magic words here are assumes joint liability. You are demanding that your AI provider shares the risk. You're contractually forcing them to stand behind the technical integrity of their own product. This makes them a partner in your defense, not just another vendor.
Okay, on to our third and frankly most critical layer, the human firewall. This is the one you control directly. This is where we redefine your professional signature and turn it into a legal defense.
This right here captures a huge shift. We have to legally define what your signature means in 2026. It's now a verified human signature. This isn't just you proofreading the output. No, this is a formal legal act. It certifies that you have validated the logic of the AI's process, using the evidence from your audit trail as your basis.
Any protocol sounds great on paper, right? But it's only as good as its performance under pressure. So let's run a crisis test. We're going to stress test this 3-layer legal firewall with an absolute worst-case scenario.
So imagine getting that call you never want to get. An undetectable AI hallucination slipped right through your review. It's in a final document, it has your signature on it, and it has caused significant damage to a client. And now they're suing.
So here's the key to your defense. You are not denying the error. The error happened. Your defense is about proving algorithmic vigilance. You use your protocol as evidence. First, you present the complete audit trail. Then, you invoke your signature as a certification of algorithmic logic. You use your contract to pull the AI provider into the liability discussion. And finally, you prove that your entire operational infrastructure was followed to the letter. The argument is simple. You didn't act negligently. You governed the system responsibly.
This protocol does a lot more than just mitigate risk. It fundamentally redefines your professional role in this new era of intelligence systems. And this brings us to a really profound shift. We're entering an era of algorithmic justice, a world where the separation between your professional ethics and the software code you use, well, it no longer exists. They've become one and the same. You know, this really gets to the heart of how our profession is evolving. Professional sovereignty used to be based on having exclusive knowledge. Now it's based on your proven ability to govern these complex cognitive systems and strategically assume the ultimate risk. So the final takeaway is this. The future doesn't belong to mere users of AI. It belongs to the professionals who become system governors, the ones who master the protocols to command these tools with accountability. Which leaves one last question for you to consider. Are you prepared to assume that final risk?